Good evening again, business law students, and hope everybody's doing great. As promised, this is going to be lecture two and corresponds with chapter two from your ebook. Um, Brief recap, I've obviously opened up module one, put some chapter notes up just to help you remember. Disclaimer that please do not look to the chapter notes to substitute for the lectures, and don't rely exclusively on that for the exams, because that would be disaster to say the least. Uh, Chapter one lecture, I'm assuming you've probably listened to that. Remember that I was looking at selected topics from chapter one in the ebook and helping you get an understanding of the Constitution, how the Constitution is structured, some key points about principles of the Constitution, including separation of powers, checks and balances, federalism, judicial review. If any of those concepts you're like, what are you talking about, professor? Definitely go back and check out chapter one lecture again. Those are really important. Some other concepts I covered, include the concept of regulation, commerce clause, and if you're like, yeah, okay, all that's tracking, professor, excellent, then you're in good shape. Because this you really, I mean, to understand the law or how it applies, you really have to have an understanding of the source of law, i.e., the Constitution, and how we get those laws. And more specifically for y'all, what are the different branches, um, responsibilities for laws, whether it's Congress and found in Article 1, which creates law, whether it's Article 2 with the executive branch for enforcement and or implementation enforcement, or Article 3 with the court system, where you resolve disputes and you interpret the law and you determine the validity of law. All right, so that's probably the best way to sort of think about it. And so, as I stated in the first lecture, no matter what your business is, no matter how large or small it is, you have to be mindful of the impact that laws have. Um, I don't, I really could not envision a business in the modern era that would not have some legal issue, legal dispute, whether it's over contracts, whether you're sued by a customer, whether an employee sues you, whether you're trying to figure out how to implement new employment regulations for your employees, whether it's minimum wage, insurance, whatever it is. Uh, I, even if you're a sole business owner, you're gonna have to deal with things like insurance and taxation and um, whatever it may be, and or contracts, for delivery of products, um, warranties, something like that. So my goal for y'all is really to get yourself thinking about, it's so expansive how laws and the legal system can potentially impact you as an employee, a consumer, a business owner, an investor. Even if you're not even an employee or have anything to do with business, but you have some stock tied up in some company, the legal system will find you, so to speak. Uh, so without further ado, then let's go ahead and dive into chapter two. Chapter two is essentially looking at, it's called Courts and Alternative Dispute Resolution. So it's kind of cool. The first part of the chapter starts off with the role of the judiciary. I've already covered that. Um, I've talked about Marbury versus Madison as the source of judicial review authority. One concept that your book does talk about that I think is important is called jurisdiction. Jurisdiction, it can be as complex or as simple as you want, but basically jurisdiction just simply means what court and where does a case belong. So for instance, if you own a coffee shop in Dallas and a customer comes in and they slip and fall, okay, those are very common in restaurant and those types of businesses. The case is going to be handled in a Dallas court, depending on what the issues are, the amount of money at stake, etc. So, it gets more complicated. And obviously, that's an easy example, but it gets more complicated when you're talking about a multinational conglomerate, or depending on what the legal issues are, where's the most appropriate jurisdiction. But I just want to put that out there, because it is important. Jurisdiction, you really have to think about, um, what it's kind of a twofold thing. One, geographically, where is a case going to be heard and managed? And then second, what type of court is going to be hearing it? Is it federal or is it state? What are we talking about? Okay, so that's a nice segue into, let's talk about the court system, okay, the court structure. Article 3 does not give us very much detail. All right, I mentioned that as a reality of the way our Constitution is written. Um, we expect we our society really does put a lot of emphasis on the legal system. Lots of TV shows are made about lawyers and the courts, books. People are fascinated with it, and there's a lot of volume that goes on in courts every day at the federal and the state level. So let's talk about the federal court system. Since this course is really sort of, it's not specifically geared for Texas, but I will mention that in a little bit so you'll have an idea of how the Texas system looks as well. But the federal court system, I want you to envision a pyramid. And at the base of the pyramid, where it's most broad, those are the courts that are most numerous. So in the federal court system, those are called district courts. Most major metropolitan areas has a federal district court. Downtown Dallas at the Earl Cabell Federal Building. I don't know if anybody's ever been there, seen it, visited, but that's where the federal district courts are for Dallas. Federal district courts are the most numerous, and they have what are called original jurisdiction authority. Original jurisdiction means where cases originate. So if a lawsuit is filed in federal court, it starts there. Now, the way I always tell students to think about it is when you watch a television show and you see a courtroom drama, as they call them, with juries and attorneys and passionate arguments and legal debates, legal arguments to the judge, and they're trying to decide guilt or innocence. We've all seen those. Those are courts of original jurisdiction, meaning that's where cases originate. And what they're trying to decide is whether someone or something is guilty or not guilty. Okay, and then what the punishment should be. That's called courts of original jurisdiction. So that's the base of your pyramid. Now, when a verdict comes down, one of the most natural things that the losing side wants to do is what? Appeal. Okay, so if a student gets they turn in a term paper in their history course and they think they aced it and they get an F and they're not happy and they appeal or ask, what can I do to appeal? And there's usually a process for appealing what they would call grade disputes, right? And it probably starts with a professor. If you don't get any relief there, you go, perhaps to the dean of the school in which that program is, whatever that appeal process is. But the concept of appealing an adverse decision is ingrained in our legal system. So the next level on our pyramid are what are called courts of appeals. Now, there's a lot less of them in the United States than there are district courts. And the way the federal court system is in the United States is divided into geographic zones called circuits. And not circus, but circuits, CIRCUITS. Although, in some cases, it feels like a circus. And depending on where you're located in the United States is going to determine what the circuit is. I believe there's like 13 circuits altogether. Texas is part of the 5th Circuit. So why is that important? Because those courts of appeals have tremendous authority over their circuits. So if the Court of Appeals renders a decision, is going to impact all the states that are within that circuit. And so it's pretty powerful. And they have what is called appellate jurisdiction. Appellate jurisdiction, spelled APPELLATE, appellate. And all that means is they have appeal authority. You don't start cases on appeal. Cases go to them on appeal. It'd be a little weird. Here's a way to think about it. Going back to my term paper example, that'd be a little strange, to say the least, if you emailed the dean's office and said, I would like to appeal a my term paper grade, and they write back and they say, well, what did you get? Well, I haven't gotten a grade yet, but I just want to appeal it. You're missing a huge step there. So appeals courts, they only get cases that have been finalized at the lower level and are now being appealed. And what I also want students to think about is kind of off to the side, since our legal system has some very specialized complex areas of law, they have specialized courts for that. So for instance, at the federal level, they have bankruptcy courts, which only hear bankruptcy, which is important for business. They have immigration courts, okay, which are important for businesses, especially during the current political landscape, right? You've got tax court, which tax laws can be extremely complex. They have courts that just hear that. They also have a military courts, of appeals that just hears military cases. If there happens to be some crossover, potentially with businesses and military, employees or consumers or something like that. So I bring that up. So our legal system is very complicated, but there's a logic to it. All right. So what's beyond the Court of Appeals? Well, at the very top of our pyramid is the U.S. Supreme Court. It's the highest court in the land. So they're the final stop on the legal pathway. There's only 9 justices that sit on the U.S. Supreme Court, and they have final say over any cases that come before them. Now, the U.S. Supreme Court, with jurisdiction, they are mostly an appellate court. However, they do have some extremely rare original jurisdiction authority. We're not going to look at the examples. It doesn't matter for this course, but I just want to put that out there so I don't mislead y'all. You don't see these cases very often, but there's a few carve-outs where it is they have original jurisdiction. So it'd be really weird, but a case could start at the U.S. Supreme Court level. But most of their cases are appellate jurisdiction based, and they have complete discretion on what to hear. You can't force the U.S. Supreme Court to do anything or hear anything. So that's kind of, that's important to know. All right. One thing about jurisdiction that I want you to know is that sometimes there can be debates and legal arguments over proper jurisdiction. Why would anybody care? Does it matter? It does, because certain jurisdictions are known to be more pro-business and others are known to be less business oriented. So a lot of times businesses try to, depending on what side of the lawsuit you're on, you're trying to figure out what the best possible location is for the case, so you can be, sort of have quote unquote home field advantage. So that's important to realize too. All right. Now, our state court system here in Texas is very similar. Again, think of a pyramid, and at the base of that pyramid, it's a little bit more complicated because we have a lot of different types of courts that businesses could potentially be in. For example, they have small claims court. They have county courts. They have district courts. So there's a lot of different courts at the state level, and they all are governed by different rules on, what cases they can hear, what the dollar amount is oftentimes guides their court jurisdiction. And then if the cases are heard there, and then if there's an appeal, they would go up to, for example, in Dallas, they have a Dallas Court of Appeals. So Dallas Court of Appeals could hear that. And then if the case gets appealed above that, depending on if it's civil or criminal, in Austin, we have 2 high courts. We have the Texas Supreme Court, and they have appellate jurisdiction. And then on the criminal side, you have the Texas Court of Criminal Appeals. Because remember, why I'm even mentioning this is, remember in lecture 1, I told y'all that you could have a scenario where businesses and potentially CEOs or employers, staffers are facing both criminal and civil penalties. And so cases can make their way up, through the chain. And so I just want y'all to have sort of a working knowledge of our court system. And so let's see. All right, so that's pretty good overview of our court system. Let's talk about lawsuits. All right. I mean, I would think that the odds are pretty good. Most of y'all have seen legal dramas. You've seen movies with lawsuits involved. Some of y'all from your intros want to be attorneys, and I am one. So it's it's really what I found very interesting, and I still do, is when I was in law school and after I became a lawyer, and I would watch legal dramas and movies and TV shows and books. I was always curious to see how they portrayed the law versus the reality of practice in courtrooms, et cetera. Because, for example, I think a lot of people think that most lawyers spend their days in courtrooms, just like you see on TV. Nothing could be further from the truth. I would say the overwhelming percentage of attorneys never touch a courtroom. Even if you work for law firms that represent businesses and your title is litigator, because I have friends that have that, many of them rarely ever see the inside of a courtroom, as strange as that may sound. But some areas, like in criminal law, like what I do, we live in courtrooms, and it's just it's just kind of interesting. So a lot of for example, family lawyers, you're going to spend a lot more time in court because of the nature of that type of law. So I put that out there just to say that that's one misconception I think some people have. It's like you could work as a corporate lawyer and never see a courtroom your entire career. That's very common. So let's talk about some basic vocabulary just so you're tracking that. The generic term that can be used is litigation, and your book talks about that. Litigation is anything where the court system is either involved or potentially involved. Because one of the things that happens sometimes is that the lawsuit never gets going because there's a threat of a lawsuit and it gets resolved. So let's give a real world example. There's two things I really am passionate about. Number one is coffee. I'm a coffee guy. Love it. Can't live without it. Can't imagine a world or reality without it. Love coffee. The next thing I really love are animals. And, I think I told you on my bio, I'm a cat dad. I've got 3 of them. They're all rescues. My first one is Vixie. She's over 15 years old. Um, you know, queen of the house, and rescued her, adopted her from Petco, and she's still going strong. And then last year at the office, right before the big rain floods hit, they one of my colleagues rescued 2 kittens out of our back secured access parking lot, and they needed a foster home. About 3 or 4 months in, actually, it was just around this time last year. They asked me to foster them, so I took the brother and sister in, and then one thing led to another, and I adopted them. So they're brother and sister. They're my babies. They're my children. If I could claim them on taxes, I would. You can't, but that doesn't matter. I still think of them as my children. So if you combine those 2 things, what do you get? Well, don't be surprised if sometime, somewhere, some way, I open a cat cafe. I would love to do that. I think it'd be so much fun, and it would just be, combine 2 passions. But say that for another day. The So let's say, let's keep it real simple. Let's say that you really love coffee too, and you decide to open a coffee shop. Now they're very common. It's not hard to find coffee shops, and on the surface, they may seem fairly simple. But anytime you're dealing with customers, you got people coming in and out, you're dealing with hot products, food, drinks, there's going to be accidents, and there's more than likely going to be either the threat of or lawsuits, either from consumers um, at your establishment. Maybe you're in a contract dispute with suppliers, distributors, or from employees. Someone's always late to work, or they don't, they're not practicing proper protocols with the coffee or food or whatever. So you fire them, and then suddenly you're being sued for some employment action. We do cover a little bit of employment law later on in the modules. Not, I think, I think it's part of module 3 is when I get to it. Um, so let's say you're running your coffee shop, everything's great. A customer comes in and slips on a spilled latte. Down they go, and they, break their ankle. All right. Um, so what happens? Well, you're very sorry for it, obviously, and then they end up having to miss work or they can't go on a vacation that they planned. And it all stems because somebody had spilled a latte and your establishment didn't clean it up. Is there a lawsuit there, and how strong is it? Well, when we give hypos like that in law, I'll use the phrase it depends. There's a lot of factors that go into assessing the strength of the case. That type of scenario is called, in the business law realm, slip and fall cases. And I am not kidding. There are law firms that specialize in representing major companies on slip and falls because they're so common. And so these companies will contract or retain these firms to deal with all the slip and fall cases. Where, because you ever walked into a store, I know everybody has, and you'll have that, you'll see that yellow pylon that says caution, cleanup, or something, and it looks all slick, and you almost slip, and like, is this, are they really taking precautions? I, I myself have told them sometimes, when I've seen that, I said, by the way, I'm not trying to get, not trying to get into your business, so to speak, but I just want you to be very mindful if there's some liability potentially here. I said, I'm a lawyer and I know that. And they're like, oh my gosh. I said, no, 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 I'm not that type of lawyer, but I'm just telling you that being a lawyer, I see liability. I see the potential problems. And the reality of a lot of businesses is they just don't think about it. The employees aren't thinking about it, the managers aren't really thinking about it. But if you're owning that business and a slip and fall happens, you'll be thinking about it. And so let's say somebody falls. Now, what usually happens? Well, a lot of times, if somebody's injured like that, if you've ever seen those ads on the side of a bus, a billboard, a TV, radio, where they're like, have you been injured? Contact our law office. Those are called personal injury law firms or lawyers. And their business model is all around volume of business and getting the cases processed for a settlement. What I find very interesting is they always talk about, going to trial and all that, but most of these personal injury firms are not about that. They may take some of the very high profile cases to trial, but they're more about volume. They want to get in, sign the clients up, and get as much money as they can from either the business or the insurance company, and then settle the case and close it out. I know that because I've got colleagues and friends that have worked at many of these firms, and it's a volume business. So, they're not trying to take all of these cases all the way through trial, and so that's always something when I see these ads, and they make it seem like they're going to take every case to trial for you and get these huge verdicts, which is not the way it works at all and not accurate. And some of them have gotten into problems for false advertising because there's ethical issues with that. So let's say at Java Land, that's the name of your coffee shop. Everything's rocking and rolling. The baristas are popping, everything's great, and then all of a sudden somebody slips and falls on a latte. Now they go talk to a lawyer, and the lawyer says, "Well, let me look into this." And a lot of times, what they'll do is they will initially send what's called a demand letter. A demand letter is basically where a lawyer will reach out on behalf of a client, and they'll say, this client has retained our firm and has been injured, and sometimes they'll go into great detail about the nature of the injuries or what they're asking for, and they say, before we file a lawsuit, might you be interested in settling, working this out? Because a lot of times the businesses may say, yeah, that was totally on us, and we're willing to settle for X amount of dollars. And the lawyer will say, hey, they're willing to pay, say $10,000 for you missing your trip, being out of work, pain and suffering. you can take 10,000 now, or this can be drawn out. And sometimes, actually, often a client will say, yeah, that sounds fair. Um, because the lawyer will say, yeah, we could have a check by in a couple of weeks, as opposed to dragging this out for 2 months or longer, or year, or whatever. So it's not unusual for cases not to even involve the court system, but the threat of litigation is there. So let's say that the Java Land contacts their legal counsel, and counsel says, well, let's look into this a little more. So I'm going to go ahead and respond back that we're rejecting rejecting their demand letter. And so what will then happen is the attorney for the customer, and the customer in this case is called a plaintiff. A plaintiff is the person bringing the case, and the entity that is defending is called the defendant. So it'd be, Jane Smith versus Java Land. And so the lawyer for Jane Smith says, okay, we're going to go ahead and file a lawsuit. There's nothing magical about it. Whenever I see or hear so-and-so has filed a lawsuit against whatever, happens all the time. It's just how litigation gets started. Now, remember what I said about jurisdiction. So depending on how much they're asking for and the location of Java Land, if it's just sitting in the middle of downtown Dallas, then they would file lawsuits, probably not in federal court, but at state court, in a district court, claiming, they're asking for however much in damages. Damages, we'll get to that in a little bit, but it's the monetary amount of dollars that they believe the case is worth, and that they can prove. Okay. So what ends up happening is the lawsuit will get filed, and the lawsuit will involve what the allegations are. That Java Land was, negligent in maintaining a safe and appropriate environment for customers, and as a result of that negligence, Jane Smith was injured, and now is asking for relief or something like that. So that's where it all starts. Now, your book goes into a lot of detail about the nuts and bolts of a lawsuit. We're not going to do that. We don't have time for all that. But one piece I do want to mention is what's called discovery. So if someone was to say, Mike, on the basis of those facts that you just outlined, how strong is the case? Remember I said it depends. What does it depend upon? Well, a lot of factors. For instance, when Jane's lawyer says, they file their lawsuit, they will request what is called discovery. Discovery is where each side exchanges information regarding the case. And what are some things that might be involved in a discovery case like this? For example, might it be helpful to know how long the latte had been there? I would think so. If it was there for a long time, that's not good for Java Land. If it just happened like 10 seconds before, and in that window, that might be a little different, wouldn't you say? I mean, if you were deciding a case on how negligent Java Land was, might it depend on the timing? Let's say so. So you might ask for security footage, or camera information, or to show when did it happen and how long did it take. Might it also be useful to know, had management been notified that there was an incident there? For example, let's say that there was a customer who came up to the barista on duty and said, hey, by the way, sorry, I just dropped my latte over there and it's a complete mess. And the barista said, yeah, we'll get to it when we get to it. Might that be important to know? I would think so. If they snap mind your own business or something like that, I would think that'd be useful. So when did they have notice of it? And then what action did they take? I'll get to it when I get to it. It's probably not going to make Java Land look that good, right? And then, for example, email communication. After this happened, let's say there were some internal emails between the barista, the manager, the owner about, oh, it's like, wow, I'm really surprised it took this long to get sued because people are always spilling stuff and we're awful at cleaning up. Nobody wants to do it. We really need to think about this in the future, or we're going to keep getting sued. But we're lucky to have gotten this far. Might that be important? I would say so. So you see how these facts, depending on what they are, can really change the strength and dynamic of a lawsuit. Because if all that's presented, suddenly it's not making JavaLand look that great. So that's called discovery. And discovery can come in different shapes and sizes. It may be video, maybe email, it may be witness statements, it may be tangible evidence, maybe I don't know, like the texture of the floor. For example, I've been in places, and I'm sure you have too, where the floors, even when there's nothing on them, it's slick. And I've thought to myself, why in the world would you create a business with lots of customer traffic and put these slick tiles that you almost have to have a natural grace and balance to navigate, right? I mean, think about that. Next time you're out, what kind of flooring do they use? And did they make a good choice? Now, see, what I'm getting y'all to do is starting looking at the world or businesses in a different way, and you do. You cannot help it. When you start studying law and if you become a lawyer, you will look at the world in a completely different way. It's just something else. So when you're trying to do discovery, it is often a key piece of a case because that's how you're really going to know. Both sides are going to know what the strengths are, what the weaknesses are. Should we settle? Should we go to trial? Big decisions. So some ways that you get information, for example, they call it production. That's where things are produced. They have depositions where you are able to bring people in and sit down and question them. Were you the barista on duty? When did anybody tell you? You're under oath. Yeah, I was told. What was your reaction? Well, I may have popped off and said, I'll get to it when I get to it. That type of thing. It's called deposition. So as a business owner and employees, they may be subject to that. And if you think about it, if you're thinking, wow, this sounds time consuming and potentially expensive, it can be. That's why a lot of times there is an advantage to avoiding taking a case all the way to trial and just reaching some sort of settlement. So let's kind of talk about that. How do cases resolve? Well, cases resolve in different ways. Some cases, if you were to watch TV or movies, it seems like every case goes to trial. I remember when I was in law school, I was in love with Law and Order, the original, not all the derivatives, the original Law and Order. And it seemed to me, because I wanted to be a prosecutor, I thought prosecutors handled like one major case and that was it, and everything went to trial. No, that is not the way the world works. And so a lot of cases will end with a settlement where they'll do discovery. Both sides realize their case either wasn't as strong as it was or has weaknesses. And they're like, how can we work this out? And one of the things to think about is if the case was really, really strong against JavaLand, why would Jane and her lawyer want to settle as opposed to taking all the way? Because trials are unpredictable, they're time consuming, and Jane may just want it to be over. She'd rather take a known quantity than deal with the drawn out process. Plus, you're uncertain. Jury may not, despite the strength of a case, doesn't mean they're necessarily a judge or a jury is not necessarily going to find for the plaintiff. Okay, so there's uncertainty. So they settle often through settlement. They can be a full-blown trial, which we'll talk about in a second, or sometimes, depending on the claim, the defense may file and ask the court to throw the case out. They may say, there's nothing here, judge. This is just a bad claim. And they'll ask the case to be thrown out. The judge agrees with them, case over. Okay, so that's how a lot of cases end up getting resolved. So let's talk about trial. One of the things that happens at trial is it's a process. So they can either be in front of a judge or a jury, depending on what the parties want. And there's advantages and disadvantages to both, like anything else. And so, we're not going to go into all the we could spend hours talking about the details of a trial, but essentially what happens is both sides have a chance to present a case, and then it's up to the judge or jury to determine um, who they're going to side with. And again, one of the things that's being asked for in civil trials often is what are called damages. Damages is kind of the generic term, and damages come in different types. So, for instance, one type of damage is called compensatory, where you're compensating a plaintiff for example, missed work, um, missed vacation because they could not go on their cruise because they had an injured ankle. They had to reschedule things and that cost them. So whatever you could basically say, look, but for this, um, by the defendant, I'm out these dollars. So that's called compensatory. Then you have what are called punitive damages, where it's like, look, Java Land is just, they really have a callous disregard for customer safety, and they need to be punished and held accountable. So we're going to talk later on in this module, not tonight, but later in the module about when I use the term negligence and what that means, etc. But that's for a different day. This is just chapter 2 is really about looking at the mechanics of a lawsuit. So that's called damages. And then again, one thing Jane needs to keep in mind is even if the jury or judge finds for her and awards damages, there's going to almost always be an appeal. The business or the defendant has nothing to lose, and they also can kind of, maybe the appeals court won't agree with that. So, a lot of times people don't want to go the trial route because their lawyers will tell them it's better to take a known quantity. You'll have a guaranteed check. There won't be an appeal. It takes the uncertainty out, and why don't we just settle this, even though it's not perhaps as much as you potentially can get. So a lot of times what ends up happening is, after discovery, before trial, there's a lot of negotiation. For example, Jane's lawyers may say, we'll settle this for 25. Java Land says, we'll give you 15. Right? Well, how about we meet in the middle and do 20? We all go home. And they're like, no, we'll do 17. And then James says, well, I tell you what, if you can get them to give me coffee for life, um, I love their coffee. I'll do 17 and coffee for life. And Java Land says, really? Absolutely. VIP, good customer relations. Here's your check. Here's your VIP card. Boom. Now, does that go on? I don't know. I just made that up, but I could see creative solutions like that. I mean, especially if somebody's like, well, I really love this company. I just really want to be compensated. I don't care as much about punishing them, but kind of cool to have free coffee for life. And, lawyers are very good at creative solutions. We are. I mean, it's part of the process is, well, what it's going to take to get your client happy, and how do we make sure that we minimize risk, because a lot of this strategizing is about risk minimization. All right. Okay, so let's talk a little bit about the concept of, because I started mentioning it when I mentioned negotiation, alternative dispute resolution. ADR is a concept of how cases can be resolved without the necessity of trial. Okay, it's real popular because courts are backed up, lawsuits take a long time, and people, businesses, everybody wants to, just move on to other business. So on page, looks like 65 of your ebook, there's a really good chart called Types of ADR, and there's negotiation, like I mentioned, where the parties will try to work something out amongst themselves. And sometimes in smaller, if their parties are really closing in on something, they can do that. Now, what happens if the issues are such that you need to bring in a third party to help structurally guide the negotiation and potential resolution process? That's called mediation. Our cases that I do in my specialized unit, we use mediators a lot to try to reach a resolution. And mediators is where you bring in a neutral third party, often a lawyer, who has nothing to do with the case, and they're specially trained to be mediators, and they will help the parties, sort of navigate, be realistic with the options, and try to reach something. And mediation is very cost effective. Like I said, sometimes you just need a third party to come in and intervene. And then finally, arbitration. Arbitration is a little bit different. Arbitrators are where they'll listen to the case and then they'll just decide who's right and how much it's worth, and it's binding. Binding arbitration is very common in the business world. You'll enter into contracts where the contracts themselves will say, um, this contract, if you're signing it, you're accepting the fact that any litigation or disputes will have to have binding arbitration as part of it. And so, they even mentioned that in your ebook that the parties include an arbitration clause. And so it keeps businesses sort of protected from having to be dragged into court all the time. All right. So, okay. So that is basically everything that I wanted to cover from chapter 2. Like I said, your book kind of goes into more of the nuts and bolts, and I didn't want to do that. I don't do it for my business law students, even when we're not in a 4-week course, but I certainly am not going to do it for y'all. I mean, I find it interesting, but I don't, like I said, feel free to read it, but you're not going to be tested on it. I hit the high points because honestly, discovery is a huge piece because that often will guide what direction the case is going to go, depending on the strength of the evidence that's found through discovery or the information that's gleaned from that. And then, like I said, just keep in mind, despite what Hollywood shows us, most cases do not go to a full blown dramatic trial um, for various reasons. And there's people just want the case over. You want a guaranteed outcome. You want to minimize or eliminate appeals. Um, and also, there's a risk you may lose. I mean, just because you have a strong case does not mean trials can be very much a roll of the dice, and you don't you don't want to be on the losing side of that if you can avoid it. So sometimes it's better to take a known outcome and just go about your business. And then the alternative dispute resolution is important for business because again, a lot of cases are going to be resolved without the necessity of going through a court process. All right. Well, I'm going to get this posted, and thank you as always. It's always, really, like I said, I love this course. I love the material we're able to cover. And then next lecture I'll be posting will be chapter 3, which is on ethics. And that's a really important chapter. It's kind of strange. We're talking about courts, and then all of a sudden they drop the ethics right in the middle in chapter 3, and then go back to some legal principles in 4. But, I didn't write the book. So I'll cover it in order so as to avoid confusion. But we'll do ethics next time, and then chapter 4 looks at the world of tort law, and that's where we'll get into looking at some of those concepts like negligence or anything else. So that being said, have a great night. I'll get this posted and appreciate y'all. Bye bye.